plaintiff number 1A to 1F, and they adopted the written statement of defendant number 1. The defendants stated in their written statement that the present suit is not maintainable as filed without valid cause of action. Hence, it is fit to be dismissed with cause. It has been submitted that suit has been filed with wrong and incorrect statements to lay false claim over the suit land on the basis of false document, and suit is bad for non-joinder of necessary parties. The suit is hit by the principle of law of limitation, acquaintances, and the law of adverse possession, estoppel, waiver, and provisions of specific relief act. It is submitted that the allegations contained in para 1 of the plaint are not admitted, and hence the plaintiff is put to strict proof of the same. The allegations contained in para 2 of the plaint are partially correct and partially incorrect. It is true that the Rayat's land of Khata number 6 were recorded in the name of Uttim Mahto and in cadastral survey and settlement operation. It is also true that Uttim Mahto remained in possession over the land. It is true that Uttim Mahto died leaving behind his son Deglar Mahto, but Jodhan Mahto was not the son of Uttim Mahto. Out of 3, Jodhan Mahto was not the son, he was the son of. The allegation that Deglar Mahto and Jodhan Mahto remained in separate possession over the land is not correct and hereby denied. It is submitted that Deglar Mahto died leaving behind his widow Mosamad Bhatia and his son Mahavir Mahto as legal heirs. The statement contained in para 3 of the plaint are not disputed. It is true that the land of Khata number 96 of village Achal Jamo were recorded in the name of Somar Teni in the cadastral survey and settlement operation, who all along remained and continued in possession of the same. In the course of time, Somar Teni sold 0.46 acres of land in plot number 6555 under Khata number 96.
What were the issues framed?
Issue is at page number 31. The first one is regarding the maintainability. Second one is cause of action.
What is the finding with regard to issue number 6?
Before that, Your Ladyship, may I submit? Your Ladyship, may kindly see the issue number 4 with regard to limitation.
Yes. Issue number 4.
Issue number 4 is at page number 50.
Page number
50 and page number 30 of the trial judgment.
Yes. Issue number 4.
Issue number 3 and 4. The burden to prove that the suit is barred by law of estoppel, waiver, acquaintance, and law of limitation and adverse possession. Burden lies upon the defendants. But defendants have not proved these issues, therefore these issues are decided against the defendants. The defense of limitation has never been challenged by the defendants in the original suit. But as per the section 3(1) of the Limitation Act,
how is it barred? They are just seeking a declaration of their right, title and possession.
On the basis of one sale deed which is executed in the year 1888.
So what?
For declaration
they can seek a declaration on the basis of their title deed any time.
But for the declaration of title,
you see, you have a property by virtue of a registered deed.
Yes.
Do you go and get a declaration from the court that it is valid? The question of its validity comes only when there is some dispute.
But the dispute has never occurred.
You see, the question of there is no limitation to get a sale deed valid. There is a limitation to challenge the sale deed. So it has got no relevance.
The declaration of title, Your Ladyship, kindly see Article 58 of the Schedule of Limitation Act. For what?
The limitation. Article 58.
Article 58.
Yes.
To obtain any other declaration, 3 years when the right to sue first accrues.
Yes.
So the right to sue first accrues in the year 1988. Your Ladyship.
Well, who disputed that in 1988?
But the dispute has never come even in the year 2000 or 2001.
So there was no cause of action.
With regard to the case of the plaintiff regarding the dispute arises in the year 2000 or 2001, in the written statement they have admitted that this has
ये
never.
सेकेंड अपील का पॉइंट नहीं हो सकता मैडम, उसके अलावा क्या बताइए?
Ladyship may kindly appreciate article.
I will appreciate, don't worry about it.
The next article is 65, Ladyship, regarding the possession over the land. Just for once, Ladyship, kindly see
65 is adverse possession.
Yes, Ladyship.
So, did you plead adverse possession? You were the defendants.
Yes.
Did you plead adverse possession?
I'm pleading title over there.
So when you plead title, you can't claim adverse possession simultaneously.
But there is a prayer in the plaint regarding the confirmation of the possession also.
Okay.
And my submission is that the possession is still with the defendants, and that has come in the trial court order. So I'm submitting the possession is still with the defendants. They are residing in that land.
There is a finding that the possession is with the defendants.
No, it is cited against the defendants, but the submission is that they are still in possession. For that purpose, a commissioner should be appointed for verifying of the.
ऐसा नहीं होता मैडम, सेकेंड अपील में ऐसा नहीं होता. इशू नंबर 6 बताइए. What is issue number 6? That was the main issue.
Yes, regarding the plaintiff's title over the suit land be declared and his possession over the same.
Read this. Read issue number 6.
Issue number 6. That this issue is main issue has taken up for the very first for deciding the real controversy between the parties. The main question before this court is as to whether on adjudication the plaintiff's right over the land suit land be declared and his possession over the same be confirmed. It is this issue has been settled against the defendant.
Yes.
May I read the finding?
Yes, you come to the finding from the perusal of documentary evidences. You can just read this. Page number 47, according to the pleadings.
According to pleadings of defendant, at the time of death of Devdar Mahto, his son Mahabir Mahto, original defendant number 1, now dead, was major and thus inherited equal half shares in the property of his father along with his mother. It has been pleaded that at the time of death of Devdar Mahto, the total area of Khata number 6 was 12 acres, 14 decimals, and Khata of 96 was 46 decimals. Accordingly, the total area of both the Khatas become 12 acres, 70 decimals. As per the pleading of the defendant, half of the shares belong to Mahabir Mahto and Musammat Bhagia. Defendant also submitted that Bhagia Devi sold total 1.21 and half acres of land through a sale deed number 5611 to Kaila Mahto. Defendant claimed that Bhagia Devi does not have any rights to execute the sale deed in favor of Kaila Mahto. Therefore, the sale deed is inoperative, void, and accordingly, sale deed executed in favor of Kaila Mahto and in favor of Talo Saw is also inoperative.
So therefore, there was a claim of the plaintiff. There was a claim of the defendant that the Bhagia Devi did not have the right to sell the property to Kalia Mahto because Mahabir Mahto was major.
This is the first one aspect of the issue.
Yes.
Even if we consider that the Mahabir Mahto was minor at the time of the sale deal, then also without the permission of the court, the property cannot be transferred of the minor son without the permission of the court. On this point, I am relying.
No, there is no need to all this. Whether he was minor or major,
the property cannot be sold out.
Even if he is major.
Yes, without his signature, without his consent, a property cannot be transferred.
Cannot be sold out.
Both were having equal shares over the land. And in case if he was minor, then according to section 2 of the.
So therefore, whatever you are saying, then Bhagia Devi, according to you, did not have the. Just a moment. Defendants also submitted that Bhagia Devi sold 1.21 and a half acres of land through a sale deed to Kalia Mehto. Defendant claimed that Bhagya Devi did not have the right to execute the sale deed.
Yes. She is not having the right.
And if he was minor, then she had the right.
But without the permission of the court, also she is not having the right to sold on the behalf of her minor son. As per the Hindu Minority and Guardianship Act also. Ladyship may kindly see the report of the circle officer once.
No, we will not see that.
It has been exhibited. It has been exhibited to ladyship.
Yes, it must have been exhibited. ऐसा नहीं होता report
But the
discussion.
trial court and the appellate court have
Second
not
appeal में
considered.
ऐसा नहीं होता है.
They have not considered the documents which has been exhibited. It is a documentary evidence. The court must have to look over the documentary evidence.
Which is that exhibit number?
This is exhibit number E and exhibit number F. The operating part at page number 28 of the judgment.
This has been discussed in page number 40, page number 28. It has been referred to.
Yes, 28 and further on 29. May I read? 28 page number. The allegations contained in para 9 of the plaint are incorrect, false and are hereby denied. The allegation that the plaintiff cultivated the land to the knowledge of the defendant who never raised any objection is totally false and hereby denied. The allegation that plaintiff by remaining in actual possession over the land of Schedule A acquired and perfected indefeasible title are totally false and hereby denied. It is submitted that Mosamad Bhagya never sold the land of Khata number 96 or 6, either for herself and on behalf of a minor son. It is submitted that there arose no legal necessity for selling the lands of Khata number 96 and 6 as alleged by the plaintiff. The registered sale deed of the year 1979, which is alleged to have been executed by Mosamad Bhagya for self and on behalf of a minor son Mahabir Mehto, is forged and fabricated document created for the purpose of false evidence and to lay a false claim over the land of Khata number 96 and 6. It is submitted that Wendy did not acquire any right, title, interest and possession over the land of Khata number 96 and 6, which are alleged to have been sold by Mosamad Bhagya for self and on behalf of her minor son in favor of Kaila Mehto. It is submitted that if Kaila Mehto got his name mutated on the basis of such kind of sale deed, it must have been done in collusion with the Anchal staffs and without any valid order of the competent authority. It is submitted that no notice or istihar was published in the village and the alleged mutation in the name of Kaila Mehto must have been done without the knowledge of Mosamad Bhagya and Mahabir Mehto. The mutation in the name of Kaila Mehto was done after the death of the Kaila Mehto, not in the lifetime of Kaila Mehto. Firstly, the last para, it is submitted that Kaila Mehto himself did not acquire any right, title, interest and possession over lands of Khata number 6 and 96 in favor of the plaintiff, and hence the registered sale deed dated 11/1/1988, which is alleged to have been executed by Kaila Mehto in favor of the plaintiff is illegal, invalid, void and without consideration. It is submitted that the plaintiff did not acquire any right, title, interest and possession over the land. The second paragraph, page number 29, it is important to place. It is submitted that legal inquiry was made on 9/12/1991. Before that, it is submitted that Mahabir Mehto, the defendant, filed an application before the Anchal authority, and accordingly a proceeding bearing case number 8 of 1992-1993 was started in Anchal officer Vishnugarh. It is submitted that Mahabir Mehto represented that Kaila Mehto set up an impostor for executing a registered sale deed in name of Mosamad Bhagya and her minor son, the defendant. And then after the dint of influence got rent receipt granted through Karamchari Baleshwar Lal. It is submitted that the local MLA Shri Teglal Mehto also requested to make spot inquiry and a spot inspection in the matter. Further, the on-spot inquiry was conducted and the legal inquiry was made on 9/12/1991. And during the local inquiry, it came to the light that Kaila Mehto from his childhood used to reside in the house of Mosamad Bhagya and used to help her in the cultivation works. as well as he has used to render services to Musamman Bhagia in the household affairs.
You just tell us, how could the court enter into the plea that this particular sale deed was forged and fabricated without there being any relief to that effect? Your entire case is based on the fact that the document of 1979, deed of 1979 and deed of 1988, followed by deed of 1988, were forged and fabricated. Correct? Did you seek any declaration for it?
Declaration has come.
In absence of that declaration, could the court enter into this? Rather, the appellate court has specifically recorded that the defendants have taken a specific stand that these deeds are forged and fabricated, but they did not file any suit for such a declaration.
As regard to the sale deed is concerned, Your Ladyship, they came to knowledge about the
But
defendants.
still, that was required to be challenged.
At that time,
Unless
the
a
suit was
registered
already
deed is
filed.
challenged, it does not become null and void, right? Because there is a lot of evidence required. It is not null and void. Then, in absence of any challenge to that, how do you say that this particular deed is null and void, and then you establish your title on the basis of that?
They have a reason, Your Ladyship. They are in continuous possession of the land, firstly, and secondly, when
Adverse
the title-
possession you have not proved.
No, Your Ladyship, this has been come in that the possession is still with the defendants.
Be happy with your possession.
Secondly, Your Ladyship, when the title suit is filed in the year 2001, then they came to knowledge of the defendants that a registered sale deed was executed.
So
way
why
back
don't
in
you challenge it? You see, come to page number 71 of the appellate court judgment. Internal page 16, bottom. Buddy, further that the sale deed is of the year 1988. On the basis of the above discussion, I am of the view, read it, page number 17.
The second point of interpretation, Your Ladyship. Page number 17 of
No,
the appellate order.
page number 17 of the appellate order, just second line.
On the basis of above discussion, I am of the view that the defendants have admittedly not filed any suit for cancellation of the sale deed. Admitted, Your Lordship. They have
Yes,
not
I read it, pura aage finding.
Sale deed number 5611 dated such and such exhibit 1A and sale deed number 470 dated such and such exhibit 1C. Even though the defendant claimed in his written statement that the same sale deed were false and did not convey any right, title, interest and possession to Kaila Mehta and thereupon to the plaintiff Talosaw. Despite the defendant's case that the defendant Mahabir Mehta had knowledge of the same in the year 1991. After the knowledge in the year 1991, they have filed one case before the circle officer, and the order
Circle
is,
officer is nobody. एक बार नहीं 10 बार बोल चुके, अब 11वां बार नहीं बोल.
Your Ladyship, but they got the order in their favor.
The deed which you are challenging as forged and fabricated in the written statement, you neither file a counterclaim, nor you file any suit for its declaration, nor can it be said to be void ab initio. So therefore, in absence of your challenge to these two deeds, no relief could have been granted.
But a sale
The
deed on behalf of the son, of a minor son, if itself is not valid.
So उसको challenge कौन करेगा? That was not the subject matter of suit. In absence of that challenge, there is nothing. That was not under challenge.
And point of limitation, Your Lordship, the post must have gone through the limitation. The same is time barred. Though that defense has not been taken by the defendants, but still it is time barred. There is judgment on this point, Your Lordship.
Essay number 59 of 2022. Heard Ms. Saman Ahmed, the counsel appearing on behalf of the appellant. This appeal has been filed against judgment dated 31/5/2022 and decree prepared on 7/6/2022. Passed in civil appeal with bracket title bracket close number 72 of 2019, affirming the judgment dated 17/9/2019 and decree prepared on 27/9/2021. passed by learned civil judge within bracket Union Division bracket close Hazaribagh in title suit number 65 of 2001. The learned counsel for the appellant, while challenging the judgments of both the cases, of both the courts, has submitted that though there are concurrent findings recorded, but still substantial question of law is involved in this case. She has submitted that the title suit which was filed by the plaintiff and based on the sale deed number 5611 dated 30/4/1979 within bracket exhibit 1 by A, followed by subsequent sale deed number 470 dated 11/1/1988 within bracket exhibit 1 by C, was forged and fabricated. She has submitted that at the relevant point of time, she has also submitted that the suit itself was barred by limitation and has referred to Article 58 of the Limitation Act to submit that suit for declaration of title could have been filed within 3 years from the date of execution of the aforesaid title, aforesaid sale deeds. She has also submitted that even if no plea is raised, even if no point was raised in connection with limitation, it was for the court concerned to consider Section 3 of the Limitation Act and examine as to whether the suit was barred by limitation. She has submitted that the sale deed executed by that Muhammad Bhagia was not competent to execute the sale deed dated 30/4/1979 within bracket exhibit 1 by A in favor of Kalia Mehto in view of the fact that the property belonged to Muhammad Bhagia and also Mahabir Mehto, and Mahabir Mehto was major at the relevant point of time. She has also submitted that even if it is assumed that he was minor, then under such circumstances, appropriate permission was required to be taken under the Guardianship Act, Hindu Adoption and
Hindu
Minority and Guardianship Act
Section 8(2).
Section 8(2) to sell the property of a minor, even if it was being sold through his natural guardian. After hearing the learned counsel appearing on behalf of the appellant and upon going through the impugned judgments passed by both the courts, this court finds that the specific case of the plaintiff was that the land in Khata number 6 was recorded in the name of Uttim Mehto and Chaman Mehto, and Uttim Mehto died leaving behind his sons Deglal Mehto and Jodhan Mehto, and Chaman Mehto died leaving behind his sons
Uttim Mehto died.
Uttim Mehto died leaving behind his sons Deglal Mehto, Jodhan Mehto and Chaman Mehto. And Chaman Mehto also died. After death of Deglal Mehto, it was further case of the plaintiff that Deglal Mehto and Jodhan Mehto remained in separate possession over the land, and after death of Deglal Mehto, his widow Mohsamad Bagia inherited the land in Khata number 6 to the extent of a share and had a minor son, namely Mahabir Mehto, defendant number 1.
The main defendant, he died further.
Defendant number 1, and she further, with respect to Khata number 96, it was recorded in the name of Soman Teli, who sold the land by virtue of registered deed in favor of Deglal Mehto, son of Uttim Mehto. After death of Deglal Mehto, his widow Mohsamad Bagia came in possession of his land to the extent of half share, and Deglal had purchased the property by virtue of personal fund. Thus, the land in Khata number 6 was the ancestral land of Deglal, having co-sharers Jodhan Mehto and Ramcharan Mehto. And so far as Khata number 96 is concerned, it was his self-acquired property. It was the case of the plaintiff that Mohsamad Bagia sold her land in Khata number 6 and 96, measuring 1.21.5 acres for legal necessity for herself and on behalf of minor son Mahabir Mehto by virtue of registered sale deed in favor of Kalia Mehto in the year 1979, and thereafter Kalia Mehto sold the property by virtue of registered sale deed number 470 dated 11/188. The plaintiff remained in physical possession of the property, and it was a claim of the plaintiff that defendant had neither title nor possession over the suit land, and the defendants held out threats on 30/7/2000 to the plaintiffs not to cultivate the suit land, and there was a proceeding under section 144 CRPC, and ultimately the suit was filed seeking declaration of plaintiff's title over the suit property and for confirmation of possession, and defendants be restrained from interfering with the possession of the plaintiff. The case of the defendant was that the suit was barred by limitation and also adverse possession, and the suit was bad for non-joinder of parties and was barred under Specific Relief Act. It was their case that Jodhan Mehto was not the son of Uttim Mehto, and it was denied that Mausamad Bagia sold the land of Khata number 6 and 96 for legal necessity for herself on behalf of minor son Mahabir Mehto by virtue of registered deed in the year 1979. It was also the case that it was also denied that Kalia Mehto remained in possession of the property, and it was denied that Kalia Mehto for legal necessity sold the land of Khata number 6 and 96 by registered sale deed number 470 dated 11/1/1988. The contention of the plaintiff that they remained in actual physical possession of the suit property was also denied. It was alleged that the sale deed of the year 1979 was a forged and fabricated document, and there was a proceeding initiated by the defendant Mahabir Mehto in Anchal office. It was numbered as 8 of 1992-93, wherein it came to light and it was also mentioned that Mahabir Mehto represented that Kalia Mehto had set up an imposter for execution of sale deed in the name of Mausamad Bagia and her minor son, and by their influence got the rent receipts issued. And upon local inquiry made on 9/12/1991, it came to light that Kalia Mehto used to reside in the house of Mausamad Bagia since childhood to help her in cultivation work and to render other services to Mausamad Bagia in her household affairs. And he remained there for more than 20 years. The learned trial court framed the following issues for consideration. Issue court continue. the learned trial court ultimately decided issue number 3 and 4 as under 5 भी इसको कोट कर देंगे, दो लाइन का है, ठीक है. 1, 2, 3, 4, 5, 6, 7 को कोट कर देंगे इसमें. The learned trial court considered the materials on record and held that and recorded the findings as under. यहाँ पे quotation है, internal page 27 में है and then internal page 28 में, 27 से लेंगे, ठीक है, till the end. The learned appellate court also considered the materials on record and gave concurrent findings and also recorded that though the defendants have claimed that the sale deed dated 30/4/1979 and sale deed dated 11/1/1988 were forged and fabricated, but they neither filed any counterclaim nor they filed any separate suit in connection with such declaration. The learned para 12 में है point for determination. The learned appellate court framed the following issues for its point of determination and recorded the finding in para 13. And 14, and held that the learned trial court has rightly held that the plaintiff has right, title, interest and possession with respect to the suit property. So far as the point of limitation as argued by the learned counsel for the appellant is concerned, this court finds that the defendants had taken a plea of point of limitation and the cause of action as was apparent was only when the defendants threatened the plaintiff to cultivate the land and thereafter a proceeding under section 142 CIPC was also instituted. This happened sometimes in the year 2000 and 2001. And the suit was filed in the year 2001 itself. The argument of the appellant that the declaration for title on the basis of the deed of the year 1979 and 1988 ought to have been filed within a period of 3 years from the title, from the registered deed is misconceived in as much as there was no occasion to seek a declaration by the plaintiff with regard to right, title, interest and possession which was in connection with the property in which they claimed to be in possession by virtue of registered sale deed, and the cause of action arose only when the defendants threatened their right over the property in the year 2000-2001. This court also finds that before the learned trial court, the plea regarding the defendants did not prove any of these issues and the same was decided against the defendants. This court finds that both the learned courts have scrutinized the material on record and come to finding with regard to right, title, interest and possession of the plaintiff, and admittedly the defendants never challenged the registered sale deed of the year 1979 and 1988, though they had challenged the same in the written statement but never filed any separate suit or counterclaim. This aspect of the matter has also been taken care of the learned appellate court, there being concurrent findings recorded by both the courts in connection with right, title, interest and possession of the plaintiff. This court finds no grounds for formulating any substantial question of law in this case. Accordingly, this appeal is dismissed.
Item 6, second appeal 194 of 2023.
Suit of affirmance, Lordship. Both the courts. On 2 counts, Lordship, the suit was filed for eviction by the respondents here who were the plaintiff. Firstly, Lordship, the arrears of rent, and secondly, bona fide requirement of the son of the plaintiff who was doing his business in a rental shop. So far as the first arrears of rent is concerned, Lordship, both the courts have come to the finding that there is no arrears.
That
is
was
my-
decided against the
plaintiffs.
plaintiffs.
Now, so far as this defendant is this second point is concerned, the honourable court, Lordship, both the courts, Lordship, have come to a conclusion that since although there are 9 other shops are there, but I cannot compel the owner of the suit land to take some other property, not my property. He cannot be I cannot make him choose over and above my property, Lordship.
And the son was running a shop in a rented property.
That is the pleading, Lordship, which has come and both the courts have considered. But now, Lordship, when the plaintiff was examined, he has said that वो घर में ही काम कर रहे हैं, घर से ही काम कर रहे हैं. That is important aspect, Lordship, which is contradictory.
घर से ही काम कर रहा है तो और ज्यादा
हाँ,
personal
that
necessity
is-
हो गया ना.
Both the things are there, Lordship.
काम कर रहा है. It is not कि सोच रहा है.
हाँ, काम कर. So therefore, Lordship, on this point, and another point was that since I was inducted by the father, we are there for last so many years. Since 1975, we are the tenants in their premises. Last occasion, Lordship, I requested my Lord to give some time so that we can vacate it. If Lordship is
How much time do you need?
yesterday I said Lordship 6 months. If Lordship gives me any suitable time, whatever Lordship will say, I'll vote on that. Whatever it is about the discretion of Lordships.
2 महीने.
ठीक.
Then I will record your answer.
Yes.
Then I will simply say that you can bring it to the notice of the executive.
Yes. That will be better, Lordship.
That would be better.
I will.
Okay, ऐसे उठा पटक
That
करने
will
से
be
क्या
best,
फायदा?
Lordship, since executing court is going on. Now many things will happen. This side, that side.
और further litigate करने से क्या फायदा?
Yes. Or 2
मतलब
months or 2
लैंडलॉर्ड
months
को भी
period.
क्वाइटस है ना.
Lordship.
लैंडलॉर्ड को भी क्वाइटस हो जाए.
Yes. For
कि
both
भाई
of
2
them.
महीना में हो
In one
जाएगा.
case, Lordship, I got the order from this court itself that I had to hand over the key on such and such date. I did that very smoothly. I shifted my everything. Everything was there. That happened.
That smooth shifting has to be there.
Yes. Because entire shop is there. My garment shop is there. Lordship.
अभी क्या वो रेट इशू हो गया?
नहीं रेट इशू नहीं हुआ. कल डेट था. Yesterday there was a date for issuing of rent.
Issuing of rent?
Only one request is that he is saying that 3 months if Lordship can. That is sufficient, Lordship. If Lordship. Because
इतना ऑब्जर्वेशन से हो जाएगा एग्जीक्यूटिव
हाँ,
उतना तो
हाँ.
एकोमोडेट कर देगा.
Yes. They will. Only Lordship will say that this is the undertaking given by the appellants in the court, and 3 months time hereby granted on such a date fixed कर दिया. On such and such date, he will hand over the key to the defendant, to the respondent. That will suffice before the executing. Even the execution is over. Lordship can record this is the execution case is also there.
Right.
Execution case number 6 or 23.
I will simply say that on instruction you have given an undertaking to evict the property within a period of 3 months, and I will just say that this aspect of the matter may be considered by the executive.
That comes.
उससे भी
They will also be at peace.
ये हो जाए.
They will also be at peace.
Essay number 194 of 2023. Do you want to contest? Should I say no substantial question of law ऐसा कुछ?
This observation.
This observation should be sufficient. Essay number 194 of 2023. This appeal has been filed against the judgment and decree dated 27th of May 2023 within bracket decree sealed and signed on 8/6/2023 passed by learned principal district judge West Singhbhum at Chaibasa in civil appeal number 5 of 2022, whereby the appeal filed by the appellant within bracket tenant has been dismissed. The decision in the judgment in the title suit is dated 10th of June 2022, decree sealed and signed on 16/6/2022, passed by learned civil judge within bracket Junior Division bracket close West Singhbhum at Chaibasa in eviction suit number 7 of 2014. The learned counsel for the appellant has submitted on instructions that the appellant is ready to evict the suit premises within a period of 3 months from today, and the suit premises and hand over the keys and deposit the keys in the executive court.
Yes. That will
And
just.
deposit the keys in the executive court, and the appellant would be satisfied if some observation in this connection is made by this court. He has also submitted that the appellants have remained single है कितने हैं? The appellant has remained tenant in the suit property since 1975. Appellant / their predecessor in interest since 1975, and he has also submitted that though the issue was framed on account of default as well as personal necessity, but both the courts have decided the point of default against the plaintiff landlord and in favor of the defendant tenant. But on the point of personal necessity, the suit has been decreed. The learned counsel has submitted that the connected execution case is execution case number 6 of 2023, in which the objection to the execution under section 47 CPC has been dismissed by order dated 12/2/2025, and the decree holder was directed to file writ on the next date. The next date was 24/2/2025. The learned counsel submits that yesterday the case has been adjourned. Correct?
Yes, Lordship.
As per his instruction, the case has been adjourned. The learned counsel has also submitted that the aforesaid submissions are being made on the instruction of the appellant who is present in the court.
Yes, Lordship.
Considering the learned counsel considering the aforesaid submissions made by the learned counsel appearing on behalf of the appellant, this court finds that there are concurrent findings recorded by both the courts with regard to personal necessity of the son of the plaintiff, and no substantial question of law as such arises for consideration in this present appeal. However, the appellant has himself given an undertaking before this court that he would evict the suit premises. And given the aforesaid undertaking before this court, in view of the aforesaid undertaking, it is sufficient to observe that the appellant may make a prayer before the learned executing court to grant him 3 months' time to evict the suit premises and hand over the keys and submit the keys before the executing court.
Latest by 25/5. Date delivery.
Latest by 25/5/2025. This second appeal is accordingly disposed of with the aforesaid observation.
That makes sense.
Dismissed with the aforesaid observation.
नहीं, ठीक है.
आप कौन है?
Supplementary serial number 2, I was appearing for the behalf of performer respondents in division. But
सीरियल नंबर 2 में क्या था?
हम ही लोग पोजिट फर्स्ट
इसको क्या किए हैं? डिस्पोज ऑफ।
नहीं, dismissed with the-
डेट शायद पड़ा.
डिसमिस तो करना पड़ेगा ना, इसका तो डिसमिस
हाँ.
करना पड़ेगा।
Dispose of with aberrant objections that can suffice. Lordship में right this.
Uh,
Dispose भी ठीक ही है उधर क्योंकि आप डायरेक्शन दे के कर रही है कि इस मेरिट पे
ठीक.
नहीं गए हैं since lordship is not entered into the
disposed of with the aforesaid observation।
None appearance में kindly.
क्या किए हैं?
वो तो फर्स्ट में भी वही रहा था फर्स्ट केस.
First case, your final disposal.
कौन सा? फर्स्ट अपील?
जब अमर कुमार सिन्हा हम लोग जो आर्गुमेंट कर रहे थे.
उसको डिसमिस कर दिए।
नहीं,
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 अच्छा वो ऐसे कैसे हैं?
Your notary, I was here just for 10 to 15 minutes. I had gone to court 9 units.
आप किनकी तरफ से?
I was appearing for performer respondent number 15, 16 and 17 units.
ऐसे हम अपीयरेंस नहीं रिकॉर्ड कर सकते।
Just for 10 minutes, I had gone to court 9 units.
नहीं जा सकते ना, केस चलते चलते मत जाए।
One and one kind units one time.
नो, ये सब रिकॉर्डेड प्रोसीडिंग में ये सब नहीं कर सकते। कल को पार्टी क्वेश्चन करेगा आपको भी और उससे ज़्यादा क्वेश्चन करेगा हमको, नहीं कर सकते।
दो केस के बाद पास हो गया.
पास ओवर है? कौन सा पास ओवर? 2 केस के बाद पास ओवर है मतलब?
सीरियल नंबर 4 जो है
हाँ।
ऐसे 360 ऑफ 18 MS जसविंदर नंदना मैडम का.
बताएंगे।
नेक्स्ट
सेकंड हाफ में सबसे पहले वही कॉल करें। पास ओवर एक ही है।
यस
सबसे पहले वही केस कर लेंगे, वो आएंगे तो ठीक है, नहीं तो केस को ऐसे ही हम लोग डिसमिस कर देंगे। पास ओवर हम 2 केस के लिए लिए थे ना,
जी.
अभी तो 1:30 बजे के बाद ऑर्डर नहीं कर सकते।